Welcome to IFERP, a forum where innovations and research interest could be supported and developed, prioritizing our mutual interest. In this video, we want you to dive into our world, giving yourself a clear insight into IFERP. But first, who are we and what do we do? Institute for Engineering Research and Publication, IFERP for short, is one of the world's largest non-profitable professional associations operating under the Techno-Elite Research and Development Association, TRADA. Welcome to IFERP, a forum where innovations and research interest could be supported and developed, prioritizing our mutual interest. In this video, we want you to dive into our world, giving yourself a clear insight into IFERP. But first, who are we and what do we do? Institute for Engineering Research and Publication, IFERP for short, is one of the world's largest non-profitable professional associations operating under the Techno-Elite Research and Development Association, TRADA, meant for research and development in the field of engineering, science and technology. We are one of the largest professional bodies for engineering professionals in India and across the globe, established in 2014. We extend to every part of the globe, with more than 28,000 professional members and 34,000 student members. Our growing membership at IFERP has led to an increase in members from Europe, Asia, Australia, Africa and the USA, fostering networking opportunities that strengthen ties within and across countries and technical communities. The mission of IFERP is to connect professionals at an integrated platform for growth to divert knowledge and skills towards the sustainable application of professional education and more. And our vision of digitalizing innovation processes through our professional networking services and more has pushed us forward to our achievements today. With our mission to make our academic services reach the top and grassroots level of institutions, we are funding colleges to organize conferences and scientific events, enabling researchers incubated at different areas of our country to directly contribute towards the transformation of India. IFERP simply connects engineers, exchange global innovation, and acts as a bridge between researchers and academics by organizing international conferences, world conferences, faculty development programs, webinars, seminars, providing membership, and more. Some of our conferences include WCASET Malaysia, WCASET Jakarta, ICAS ETAM APU Malaysia, and many more. We've also organised scientific events in association with renowned universities done in the past, with over 28,593 journal publication services, creating opportunities to get your research paper published in high impact factor journals such as Scopus Indexed, Web of Science, Google Scholar Index journals, ESCI, UGC approved, L Compandax, ISI, Shimago Index journals, and many more. To make our operations smoother and more perfect, we have been supported by our associated organisation, Association of Cloud Technologists, Global Association of Nanotechnology, International Association for Big Data Analysts, International Association for IoT, International Wireless Network Association, and World Association for Structural Engineers. We have also worked alongside several clients and partners both nationally and internationally like University Malaysia Sabah, APU Malaysia, UNJ Jakarta, MC University Thailand, Ajman University Dubai, PUP Philippines, IIUM Malaysia, ISU Philippines, FCPC Philippines, WCC Philippines SRM University, Galgotia University, Amity University, and much more government and private organisations in different countries. At IFERP, we believe that there's always a better way to treat professionals, and that is what we do. If you would like to see more or go deeper on IFERP, you can visit our website at www.iferp.in.
Hello, everyone. Good evening.
Hello.
Hello, ma'am. How are you?
Fine, and you?
Yeah, I think your video is off.
Is it okay now?
I can hear you, but I cannot see you. And Miss Namrata, ma'am, are you? Hey, hi.
Hi, how are
Are
you?
you there? I'm good. I'm good. Hello.
Hi,
Hello, both of you. How are you?
good, good. How are you doing?
I'm good. I'm good. Hello, everyone. Good evening, and welcome to our webinar series on IP challenges in engineering, science, and technology advanced concepts. We had started yesterday our first session, and today we are moving on to our second session with these lovely speakers here today. And welcome both of you.
Thank you.
Today we'll be discussing on challenges in science, intellectual property rights, and management. Before that, I would like to introduce to you our lovely speakers of the day today. I would like to first welcome our speaker, Ms. Leticia Khater Covesi, who is CEO at 19PI and collaborating professor at UNICAMP Campinas, Sao Paulo, Brazil. And Ms. Leticia, she has completed her doctorate and postdoc from UNICAMP and MBA from FGV. She was nominated in national and international awards, ILO Global Council Awards in the category of Intellectual Property Team, 2018 IFERP Pharma, and 2017 EMS, and 2015 in the individual category. Dennis Barbaso Intellectual Property Award, EMS 2016, and GTPI Jacobs Bochra Award for Academic Production in 2015. She has more than 10 years of experience in intellectual property area of the pharmaceutical and chemical industries. Today, she works as a CEO at I9PI, in addition to being a researcher and collaborating professor at UNICAMP. One of our main goals is to contribute to the management and protection of intellectual and industrial property, and to stimulate innovation through the customized application of best practices and strategies that optimize time and money. Together with entrepreneurs, academics, and partners from different areas and countries, she developed viable solutions with high added value through consulting, advice, and technical guidance in areas such as product portfolio analysis, IP management of trademarks and patents, innovation and scientific research, and many more. So thank you, Ms. Leticia, and thank you for joining us today.
Thank you. I'm very happy to be here. Thank you very much.
Thank you. Next, I would like to introduce our speaker, Ms. Namrata Pahwa. She is an advocate and intellectual property litigation, advisory, and civil dispute resolution at New Delhi, India. She handles IP prosecution for Indian and international companies and conducts raids and investigations for intellectual property matters. She also handles IP litigation across all fora pan-India, as well as advisory to domestic and international organizations in tune to their IP needs. She was recently involved in India's first standard essential patent litigation at the Honorable Delhi High Court. Ms. Namrata often conducts various webinars and talks to impart knowledge. And besides this, she is also an amazing Kathak and salsa dancer too. That's really nice. And welcome, Ms. Namrata. Thank you for joining us today evening.
Thank you so much for having me. My pleasure.
Thank you so much. And once again, good evening to all the attendees who are watching us live on YouTube as well. So without any delay, first we will move on to Ms. Leticia for her presentation. Ma'am, are you ready? Can we move on to the presentations?
Yes.
Yep.
Yes. You may begin.
Okay.
Yeah.
First of all, I'd like to thank you very much. And I saw at your video that Brazil is not in the networking that you are considering. I would like you to update it because I would like to be a partner. My dream is to have in Brazil something like you have in India, because we need in Brazil more people talking about IP. It's very important for our country, and I am very how can I say, it's amazing how you are doing this great job, and congratulations for all of you, because I believe this will change the life of the people who are here hearing about IP issues, and your country will be better if more people knows about IP. And it's a pleasure to be here. Thank you very much. And today I'm going to make a kind of introduction to the next presentation, because I would like to review some topics that you have seen yesterday, and I would like to say some strategies that I believe it's good for everyone. So let's go. Okay. I would like to talk about intellectual property system, innovation, patents, trademarks, and patent due diligence, freedom to operate analysis, IP strategy, and legal contracts. And first, I would like if you can put the video from IPO just to remember how important is innovation. Is it possible?
Yes. We'll play the video. Sure.
Innovation, the uniquely human force that drives mankind's progress. Without innovation, your phone wouldn't be smart, there'd be no GPS, no music on the go, and no HD video, stories without special effects, no colour, no sound. And unable to look inside the human body, doctors would be in the dark. The intellectual property system exists to encourage the innovators and creators who make the world a better place. The World Intellectual Property Organization, a specialized agency of the United Nations, helps them do this every day across the globe. WIPO provides a forum where governments debate and shape intellectual property laws, such as copyright laws, to adapt them to the changing needs of our global digital society. WIPO's goal is to make intellectual property work for everyone. WIPO operates international filing systems that make it easier to protect and promote inventions, brands, and designs across borders. Everyone, from individual inventors and small businesses to the world's biggest companies, can file a single application through WIPO's PCT, Madrid and Hague systems to apply for protection in countries across the world. This saves them time and money. In the last 50 years, WIPO has processed over 4.5 million international patent, trademark and design applications for everything, from machine tools to medicines to solar panels. And when disagreements arise over IP, WIPO provides arbitration and mediation as an alternative to costly court proceedings. WIPO gives people the tools to use IP effectively, helping people in developing countries to make a living from their ingenuity and creativity. That means more opportunity and more jobs. Innovation requires information. WIPO provides free access to IP information, including more than 55 million patent documents and more than 25 million records of trademarks and designs. And WIPO trains tens of thousands of people every year how to access, learn from, and use all this priceless information. Since its inception over 100 years ago, the global IP system overseen by WIPO has helped create an environment where innovation and creativity can flourish. That means more minds creating new technologies to conquer the world's problems, more music and more ways to listen to it, more art and culture, and more knowledge reaching us in ever-increasing ways. Every day, creative people all over the world are finding new ways to improve our future. WIPO and the intellectual property system help make that happen.
And let me put here my video. This video is only to stimulate you to believe that innovation, intellectual property system is good for everyone. And that's why I'm so happy to be here and to talk about this topic that I love to talk about. So this video is just to introduce you, and let's go to review something that you have heard yesterday, but I believe it's good only to understand what does it mean. I know you know that intellectual property system is to protect any idea, and I'm going faster this first part because I know you have heard it yesterday, but I would like only to briefly resume this information because I believe it's good for you to know that once you have that idea and you have something to put in the market, you have a long way to go until it goes to the market. So you have to think about what is your invention protection strategy. It's good to understand if you would like to file a patent, if you have a copyright, or if you would like to open source, and then, or if you'd like to have any other kind of trade secret. I will say about some intellectual property possibilities, but it's great if you know where can you find this information, and that's why I believe it's good to remember and to spread this knowledge. So let me go here. Okay. And intellectual property system is something that imagination made real. You think about something, you create something, and you have to protect it like you have to protect your home, your car, your bank account, everything that you think and you can protect. It's just like any other property. You have to have a protection to be safe and to have more innovation in your field. So, in my opinion, knowledge is power. Once you know about intellectual property system, you can do many things that people doesn't know. And it's good to create and maintain a competitive advantage to protect the core idea of your innovation. And just to remember that one product may have many protections, like a copyright in patent design, the patents that protect it, the trademark. So you have many possibilities to protect your idea. And only a brief review, you have trade secrets, patents, copyrights, and trademarks. Trade secrets is a formula, a method, or any information that is confidential, like Coca-Cola formula and many others that you have seen yesterday. And the length of protection is as long as information remains confidential, because it depends on how many time you can keep it in secret. The patents, it's protects products and process, like machines, compositions, devices, like, for example, iPhone or drugs or many other creations that may be product or process. And the length of protection is 20 years from the date of the filing. And the copyright is for books, photos, music, recordings, videos. And for example, many books, and like Michael Jackson's Greatest Hits, and many things that you can think about the copyright protection. And the length of protection is the life of the author plus 7 years from the work. And the trademarks, it's like you have seen yesterday, it's words, symbol, logo. So like the Nike name or the Apple name or that Apple that is the logo. So it's the length of protection is 10 years, and you can renew 10 years. And what is a patent? You have seen yesterday, it's a right to exclude others from making, using, offering, selling. It's limited in terms of territory and duration. And the scope of the rights is defined by the patent claim. So it's important to understand the patent documents and to understand that the claims of the patent is the most important part of the patent to consider the protection. So you have the claims and the description and drawings. The description and drawings serve to teach, to address a person to scaling their art, to disclose the best mode. But the claims is the part of the patent that's most important to define the invention that you would like to protect. And a patents are kind of an agreement. The inventor is giving a limited period of time of exclusivity for making this invention public after this time. So it enables and encourages the continuation of science discovery and growth and welfare. So it's important to understand it. You have to disclose your invention. You have a limited time to stay only you in the market, but you have, after this time, something that you can give to the society. The society will be benefited by this kind of information. So it's very important to understand this balance. And what are the requirements? It's novelty. It has to be novel and not already known. It has to be not obvious. It's the inventive step that you have already know. The subject matter as a whole would not have to be obvious to any person who are skilled in the art. Someone who works with this technology cannot think that it's obvious to do this kind of invention. It has to be useful and has to have the details of the invention that we call written description. It has to be enabled, must describe how to make and use the invention. And you have to show the best mode. Some countries like Brazil doesn't need to show the best mode, but it's better to show the best mode, the best way to do this invention, because it has to be very, very clear what would you like to protect. Once you have to, after this period, you have to benefit the society with this knowledge. So it's better if you put in your patent in the best mode. And the novelty is something that depends on the country. You can, after a period of they call grace period, some countries operate with 12 months of grace period, other countries operate with 6 months of grace periods. You can publish something, then you go and file your patent, and it's okay. But in my opinion, and I would like to reinforce it here, it's always better to fill your patent documents before you publish anything, before you go to an oral presentation, before anything. If you have an innovation, you have to to file your patent before anything you would like to disclose. So if you disclose your innovation before filing a patent application, you can limit your ability to obtain a patent. And I believe it's if I would say something to summarize this presentation, is to always remember, do not publish anything before you file your patent, because many countries has this grace period, okay, but it's not all the countries, and the majority of the other countries are still absolute novelty, and if you disclose, you are prior right against yourself. And the novelty, if you'd like to have your patent, you do not have to publish thinking that you could stop someone to get the patents first. All litigations are expensive, are unpredictable, and the best practice is file before disclose, as I said. And even you're keeping your invention secrets, you are waiting some experiments to file, you should consider file as quick as possible, because the fields are moving faster and the research groups are more competitive. So if someone publishes before you file, it will be prioritized at your application. And if someone files before you, it gets appended, and it could also stop you to go to the market with your product. So it could be a very costly mistake. That's why I would like to also give it as a tip. If you can file as quick as possible, it will be better. Do not wait for, I have to wait this product to be the best one. No, you have to file as early as you can, and also you have time to be better, to improve your innovation, and try to upgrade this patent document until the public, until it gets to the publication. So it's something that I would like to also say to you. If you can file as quick as possible, it will be better to get the patent and to be able to launch your product. And good reasons for patents. Patents prevent others from commercial utilizing innovation. For the research-based industry, periods of market exclusivity may be important to recoup of the R&D expenditure. Patents encourage financial risk and long-term research, guarantee the dissemination of information, can be value assets of the company. Patent portfolios are often understood to provide offensive benefits as a way of box out competitors in similar technology space, and has extensive benefits as well. A defensive patent may be very good in some situations. And I would like to say something that may be more important to people who work with genetic modified microorganisms, but it's only to understand that not all the patents has the same patentable materials. It's different in each country. Brazil is like India. We allow only this genetically modified if it has novelty, inventive step, and its industrial application. And we have also production process of animals, not human, not essential biologicals, and in plants also production process of plants, because we do not allow discovery, we do not allow isolated material, we do not allow isolated microorganisms, we do not allow human or animal cells or variant, and genetically modify animals, plant cells. But in other countries, you can file a patent application, like United States, European Union, China, Australia. So you have to understand each country, each legal issues to file the patents depends on what would you like to patent. And before you start to do something, it's important to understand that you need to see if you can launch a product, if you can do this kind of research, because if you do, before you start the research, you do a patent due diligence to understand what have already been published, what patent have already been filed in your field. It's much better to you to go to the market or to start launch a product without a litigation, because costs of litigations are huge, and it's not nobody would like to spend time and money with this. But sometimes you have to fight with big companies because you did not see something when you would like to go to the market. And lawsuits are cash and time waste that can be distracted for company and employees. Except in rare cases or in many cases, their side it's very difficult to find some agreement. So if you do, before you start your research, a freedom to operate analysis, it will be more comfortable for you to go to the market and go and to do your research, and also to see if you can patent your product. A company, a startup, or an individual must do this analysis well before launch to avoid the risk of litigation, because patent protection is territory, have limited duration, and have limited scope. So you can evaluate if this patent is also valid for your territory, if it's already expired, if it has some scope that you can design around. That's important to understand everything that is has it's regarding your technology, everything that you believe that would be important for that research that you are doing. It's important to understand with this analysis. And this analysis is the ability to proceed with research, development, and commercialization without infringing valid intellectual property rights of others. And how to conduct this search, how you do this freedom to operate analysis. You can hire someone like an external provider, a patent search service, a patent firm, a patent office. You can hire a person, a specialist, a patent agent, a searcher, or you can also learn to search online. And I saw that many of you are doing some great courses to teach people to search online. And it's great. There are many databases, depends on where do you like to launch your product? Because if you are in the United States, you have to go to the American Patent Office, the USPTO. If you are in India, you have to go to the IP India. If you'd like to launch in many countries, you have to see where it's important for you to find the patents and the status of the patents to do this search. So it's very important to know that if you do this patent due diligence and this freedom to operate analysis, you will be more comfortable, more safe, and you have more probability to be success in your field. And it's a great you have to have there is many strategies to do this, but it's a huge amount of steps to know that you have already saw everything in this freedom to operate analysis. Here is only an example. You have to data collect, analyze, and preview, and you have to define the data, you have to define the technology, you have to search the correct database, you have to think about the criteria, the rates, the keywords, and with all this data, you are evaluating, analyzing, and exporting this data and try to find the best way to know which patents that you have found is important to understand if you have to wait this patent expired or if you can design around this patent. So it's very important to conduct this patent due diligence and to do this freedom to operate analysis to understand if you can launch a product. And when a relevant patent is found, when you find something that is not okay for your product, oh my God, what can I do? I will stop to do this. No, you have to look at the claims, not just the disclosure of the patent, because sometimes the claims are very strict and you can design around. Many patents can be designed around. And sometimes you design around and you can find your own patent because you could design around with an innovation that nobody has already published. So it's a great way to improve and to go to the market with more ability to the success. And if the patent has expired, it's okay. If you find a relevant patent, but it's not valid anymore, no problem, go ahead and you can launch your product without any costs and any worries. And the IP strategy may be also not only for patents, but for many things. So here is only to review and to try to remember you that it's important to keep confidentially an invention of that invention agreement and that kind of information that you think that it's an innovation and you can put it in the market. It's important to understand that you have to keep it confidential until you file your patent or until you do something that you believe that is good for you. So if it's a company, you have to have this with your employees. And you have to evaluate the core assets and to decide what type of protection is good for you. It's a trade secret. Can this invention be kept secret? Does it make business? Is it possible to have policies and ethical sense? The patent is novel, has inventive step, has utility. The trademark, your trademark, is it good? Would you like to have a better trademark? How can you improve your trademark? So you have to think about many possibilities to protect your product, because it's not only one that you can choose. You can choose, depends on your product, you can choose many things. And trademarks also, you have many ways to improve it. You have to make sure that you have a great name to go to the market with more probability of success. So you can do a Google search and try to find the PTO website, depends on the country of you are. You can try to test if it's distinctive, it's memorable. You ask somebody, what do you think about my name? I'm thinking about to go to the market with this trademark. What do you think about it? And it's important also to remember that maybe you can have your trademark later than the business, when the business change, expands. So sometimes it's good to think about the future when you do your trademark. And it's also, if you'd like to go abroad, it's important to think about international implications of the name, to think if this name could be negative in another language. And also avoid the usual spelling of name. So some names may cause confusion to the consumer. So it's good to think about an easy name, a name that would be easy to remember. And there's something that you can do, come up with 5 names that you like, test it with the market and try to see which is better. But if you try to ask for somebody that will say to you, oh, this name is okay, this name is not okay, it's also another extra to go to the good name. And it's important also to remember to have a strong structure, and it can be considered to go to the market with legal contracts and IP assignment agreement once you have to transfer this technology with some company. So it's good to understand, to find a good legal concern, a good accountant, to understand the income tax bills, to understand the legal liabilities for which founders are personally responsible, to understand everything that you need regarding legal contracts. So hire someone, or if you are a lawyer, you can do this by yourself, but you have to have some partners to understand this structure, to understand how to be safe, how to avoid litigations. It's very important because it's when we are growing, it's an important way to be safe and to grow without thinking about the legal issues. And only to remember, it's everything you are going to talk with some company, remember to sign the non-disclosure agreement, because it's very good to be safe and to do the business conversation without worrying about this. And finally, to improve the probability of the success, I believe that you have to optimize contractual terms with the help of a lawyer. You have to position on participants and stakeholders in their skill and experience, to remember that if you are good in a field and you have a partner that are good in another field, it will be better. And you have to implement an appropriate R&D and business plan if you are going to the market. In my opinion, it's very important over communication. Every time you have something that you believe it's good and it's okay, try to communicate to your partners, to the people that believe in your idea, because it will be better to redirect the efforts when necessary. And it's important to select the right seeds in the right time to understand which intellectual property challenge that will be better for you. And always find opportunities when people see troubles. I believe it's something that you have to keep in mind, because sometimes you see trouble, or I can't do this because it's a trouble, it's not okay, but maybe a great opportunity to the innovation. And also consider the provisional patent application, patent pens, because it can ensure your novelty when you are not okay to go to the market. And in my opinion, also, it's great to understand that early stage collaboration must be very, very nice to improve your success. So it must be identified at academic or biotech organization or whatever you are. It's good to understand that collaborations and partners may be great for you, but you have to remember all these tips to keep it confidential, to try to file your patent application before you publish. So that's my main information. And thank you very much.
Thank you, Ms. Leticia. That was a lovely presentation. And I hope there's no questions so far. And attendees, if you have any questions, do write to us in the chat box. And if you're a person watching from YouTube, you can write in the comment box. We'll answer towards the end of the session. And without any delay, we'll move on to Ms. Namrata's presentation. Ma'am, are you there? Hello?
Hello.
Yeah, can you hear me? Ma'am, we'll move on to your presentation.
I can.
Yeah.
Absolutely.
Ma'am, your video is off, I guess.
It's not off. I think there's some
Oh,
network issue.
Okay,
But
fine. Okay,
it
fine.
says
No
that
problem.
it
You can,
will
it's visible
get
for you, right?
fine.
The slides?
Yeah, absolutely. It's fine with me.
Okay,
And
fine,
through the
fine.
as and when the network gets fine,
Yeah,
I'm sure
fine,
you'll be able
fine.
to see me.
Yeah, sure. No problem.
Okay.
You may begin. Thank you.
Right. So, good evening, everybody. Thank you, IFERP, for organizing this and inviting me to speak. Thank you, Leticia, and the other speakers yesterday. I did hear them, and they all provided great insight. The until yeah, now you can, I guess. So until yesterday and further from Leticia's presentation that they've discussed all basic concepts. So in my presentation today, we'll discuss slightly more advanced concepts and deal with a more wider outlook when it comes to IP and engineering, science, and technology. So today, according to me, in today's time, the development of a country is decided with respect to the scientific technological advancement for sure. And along with them, the commercialization of these advancements is equally important. And this is where intellectual property rights come into the picture. So today we'll be discussing what is IP in terms of science and tech, a few challenges when it comes to patent law, a few brief concepts of compulsory licensing, what is green innovation, greenwashing, recent innovations, and how they're dealing with the current situation, which is in COVID right now. So let's begin. So now there has been rapid growth of scientific and tech advancement, which has led to a rise in number of inventions. In these inventions are therefore protected by IP law. With the rise in inventions, the laws with regard to these have also advanced. Innovation, invention is a very important part of economic and social progress. Therefore, IP provides a mean to achieve it. Now, let's discuss a few challenges when it comes to IP protection. According to me, the first and probably the most prevalent of it all is the lack of awareness among the general public regarding IP. Although the Indian IP law is quite thorough and generally comparable to European IP laws, there are still significant concerns over IP enforcement. A major cause for concern is enforcement and bureaucratic delay, with the backlog of cases at both civil and criminal courts. There is also a lack of transparency, particularly at a local level. A significant feature of the IP environment in India is a large number of small players infringing IP rights. So, if India strives to become, say, a USD 5 trillion economy by 2024-25, innovation will play a great role. The Indian government must work to address these procedural and substantive challenges, according to me, faced by these IP holders. But unlike the UK, there isn't any provision in India, in Indian law, for the amendment of the patent during litigation. So, or to enforce a partially valid patent. Um, I think it will be appreciated here that this decision may severely impact litigation by patent owners, as it appears that they can no longer rely or fallback positions in the dependent claims if the independent claim is held to be invalid. Now, before we go on to patentability, just a brief, if you can just remember or remind yourselves what exactly a patent is, which Leticia and yesterday's webinar covered. So now let's go on to what is patentability exactly. We all know patents are a key to promote innovation, research, and development. But patentability refers to the conditions requisite for a patent to be registered, so basically whether the invention can be patented or not. So, According to Section 2J of the Indian Patent Act, an invention means a product or process involving an invented step capable of industrial application. Along with these, the invention must be clearly enunciated and disclosed in the patent application draft for use of the invention by people in the field. Apart from the global patentability requirements for invention to have novelty, inventive step, industrial applicability, the Indian Patent Act has specific provisions covered under Section 3 that makes the patentability of an invention relating to a subject matter such as derivatives of a pharmaceutical drug, patentability of stem cells, diagnostic methods and kits, isolated DNA sequences, computer related inventions, amongst others, non patentable subject matter. As a result, these inventions face a higher threshold of examination and scrutiny. Now, in India, the patentability of in vitro diagnostic methods and kits in life sciences has a lot of obstacles to face. Isolated DNA sequences are likewise the subject of complaints for not being able to fulfill the criteria of novelty to be patented. It is therefore difficult on the part of the applicant to persuade the controller of patents of these things. Um, the subject matter that cannot be patented is specified in the sections of the law, but for a derivative to be registered and overcome the restriction under Section 3D, a critical contrast needs to be shown in the efficacy with regard to the parent compound. Now, Leticia has already covered process and product patents, so I'm not going to deal with that. Computer related inventions, according to 3K of the Indian Patent Act at least, um, computer programs per se or algorithms fall into 3K. This objection exists as a default for all computer related inventions. The decision in such cases is not consistent with different controllers forming their own views in terms of the requirement of hardware and if it must meet the patentability criteria. And of course, lastly, compulsory licensing plays a great role in how patent is seen in India. We'll just discuss that now. Now, before we start with the details, what is compulsory licensing? Compulsory licensing refers to the grant of authorization to a third party to use a process or a product which is patented without the permission of the patent holder. This concept is in force at both national and international levels. The provision for compulsory licensing in India can be found under sections 84 to 92 of the Indian Patent Act. The same is actually also specified in the TRIPS agreement. Now, what are the basic objectives of compulsory licensing? So, as we can very rightly deduce that the basic objectives are first to, of course, promote the general interest of the public. So, in few countries, it is actually mentioned that compulsory licensing is adopted to restrict the patent holder's monopoly and look at the wider picture or the benefit of the general public. The same has to be spoken about the laws of UK or Norway. Apart from that, there are balancing of interests, there's prevention of abuse of rights, there's public health, like we spoke about. Now, the rules relating to compulsory licensing can be majorly found in two international instruments. The first is the Paris Convention, and second is the TRIPS Agreement. Now, the Paris Convention, the provisions relating to compulsory licensing there are dealt with in Article 5A. Specifically, 5A2 of the Paris Convention recognizes the right of each country of the Union to take legislative measures providing for the grant of compulsory licenses to prevent abuses which might result from the exercise of exclusive rights conferred by the patent, for example, failure to work. And when it comes to the TRIPS agreement, there are two most important articles, which is 2.1 and 31. So 2.1 refers or states that all members of the WTO have to comply with few articles of Paris Convention and Article 5A of one of those articles. But 31 of the for the TRIPS agreement provides that a member may allow under that stipulated conditions other use that allowed under Article 30 without the authorization of the rights holder. Now, why isn't compulsory license actually mandatory? It is mandatory, but to what extent is it actually acceptable by the general public, and what are the challenges that we face as the legislature or at the public level? So there are two main kinds of challenges that are faced in implementation of compulsory license. That is, first is challenges faced by the government and challenges faced by an individual stakeholder. Now, the ambiguity and vagueness in certain clauses of international treaties leads to different interpretation by different individuals. This leads to problems in implementation at the same at the national level. Now, the WTO members are of the view that the system is complex and the practical applicability of the same always has to be questioned. Adequate operation of law and administrative framework is also required. It is known that high cost of litigation in the matter to obtain a compulsory license becomes a hurdle for people in making the right use of this exception. Also, presence of more than one administrative body to deal with these issues does make it difficult. So, of course, there has to be local and legal and technical expertise when it comes to an institution having the capacity. Uh, the policies have to be implemented, specified in the international treaties at a national level. All government departments associated with it must be in coordination. Now, when it comes to an individual stakeholder, it is known that regulations are not mentioned in detail in a lot of countries. So, to determine whether grant of a relevant patent grant of the compulsory license is required in order to manufacture a patented product, the relevant patents that cover such products need to be identified, and then the status needs to be protected. Now, let's quickly go over the advantages. So, why is there a need for compulsory licensing? It ensures that the drugs are available to each and every person. If compulsory licensing is opposed by developed countries, it will raise thoughts to neocolonialism. It can be used to break monopolies and cartels. It is greatly used in development of generic pharmaceutical industries. Patent suppression and other practice followed by patent owners, and of course a deadlock between the original patentee and the approver. So what is the situation, current situation, given that we're all in a pandemic currently, and how does compulsory licensing play a role here? So there are two underexplored provisions of the Indian Patent Act that have potential to gain particular relevance in the present time where the world fights COVID-19. These provisions are relating to compulsory licensing upon a notification by the central government. So, Section 92 of the Indian Patents Act and the provision for revocation on ground of prejudice to the public, which is Section 66. Both these provisions come into play only after the patent has been granted. These can be significant for access to diagnostic kits, vaccines, drugs undergoing trials, which are covered for existing patents. None of these clauses will apply to any vaccine or drug that is still in the stage of development and for which patent applications are pending. The Act also says that such exceptional circumstances can include public health crisis relating to AIDS, TB, malaria, or other epidemics. So basically, any patent that lessens the access to medications during a pandemic is detrimental to the general public of the country. So it will be prudent if the patents do not come in the way of cures and affordable access to such cures for COVID-19. The patent system has enough flexibility to allow for access to all during such emergency situations. Moreover, the existence of such mechanisms in any patent law will probably alert patentees, would act as a catalyst for them, probably to offer adequate supplies at affordable rates, ensure that supplies are met through their own efforts as well as the efforts of the other licensees, enter into licensing contracts on reasonable terms, show an effective public health relation exercise, and in these dire times, and so on and so forth. So globally, when we talk about the issues that there are, or certain things that are necessary, we'll quickly skim through this because this requires a lot of in-depth discussion. So of course, um, it refer traditional knowledge refers to the indigenous knowledge, skill, and know-how of a particular community or tribe. The Indian government has also created a traditional knowledge digital library to keep a check and challenge patents that are registered for the same. Now, when it comes to biotech, the problem that arise in patenting biotech inventions is that it is believed to reproduce itself. This leads to a lot of open-ended questions as to what about the protection of future reproductions, exhaustion, etc. So, also there must be a concrete practical use to register a patent for the same, along with sufficiency of disclosure. When it comes to space tech, the problem that arises here is whether the law of a particular country can protect something that is in space. I recently wrote an article about IP in space technology, and it just brought on so many great insights that I didn't know about. So the space object is governed and controlled as per the laws of the country to which it's registered. But IP provides only territorial protection. The main question that arises here is, does IP have the means to protect something that is in the outer space? Excuse me. Now, when it comes to nanotech, the issues that arise in patenting this technology is that it covers a very wide spectrum, and providing patent to the same will block a huge number of other patents. It also has an attached risk of overlapping patents. The main aim of a patent system is to promote research and development and innovation, of course. Even though the current patent system has potential, it still at times thwarts the research and development and of other technologies. For this reason, it is believed that there is a need of a better and well organized patent system globally. Now, before we go on to green environment and IP, I'll just quickly talk about copyrights and how all that also is a very important part um, of science, tech, and engineering. So, with the advancement of technology and greater use of internet, the work of copyright owners is not at risk. Uh, Unlike the traditional means when the use of copyright work was restricted only with the owner, now everything is accessible over the internet. So there is no restriction on any and every point of information which leads to dissemination of information. Technology has made sharing of anything available at your fingertips. So when it comes to copyright, things like computer programs, databases, multimedia works are hugely protected for this space. Now, when we talk about green environment and IPR, the need of the hour is to build a path forward towards a green and clean future. The effect of the climate change and the need to save the earth has never been felt more across the globe. So, what exactly is green tech? Green tech refers to innovation that entails new or modified processes, products, systems, devices which are used in the environment space, science, green chemistry, amongst others. Such things which promote sustainability, excuse me, and conserves the environment. Um, a great step taken forward in this area was the IPC Green Inventory by the International Patent Classification. Green innovation, as we all know, is today's need, and more so in India. Along with being the largest democracy of the world, it is also the fastest growing economy. Therefore, there is a dire need of sustainable environment practices in India. India has already taken lags behind the world when compared to other countries with regard to environmental policies. So now that we understand the importance of green IP and how we should limit our footprint on the globe, there are still a few companies who are indulging in something called greenwashing. Now, what is greenwashing? So, consumers across the world are now looking for making a shift towards sustainable living. The issue that arises here is that the companies that are making the use of the shift in mentality of the consumers and are exploiting them. The companies advertise their products as eco-friendly or green or biodegradable, amongst others, and the consumers are fooled by it without really looking into the actuality of it. Therefore, when various companies advertise their products as being eco-friendly or environmentally safe without the product actually being the same, that is claimed as greenwashing. And the major, I would say, need of the hour is more awareness and more knowledge amongst the consumers, because the lack of the same is that is the reason why they're falling prey towards greenwashing. Now, similarly, let's come to green IP. Now, green IP refers to the protection of such IP that have brought innovation to the field of technology, which will conserve the environment. With the advent of these innovations in technology, there is a need for the procedure which will fasten the procedure of protecting the green IP. So, in since 2009, many patent offices, mainly in the industrial countries, have put in place schemes for fast-track green patent applications. These include the UKIP office, the USPTO, and the Korean Patent Office, amongst others. Um, in fact, the Brazilian National Institute of IP announced a pilot program to accelerate the green patent applications, and uh, it's a great honor for us to have Leticia on board, so that hopefully later on she can give us some input on this. But I would love to know something more about this as well. So green IP can also be protected under trade secrets. There are various approaches that need to be adopted in this regard, uh, so as to encourage innovation in green technology, to disseminate information, and permit transfer of green tech in different nations. Now, what are the various ways, or has there been enough um, ways that the world has um, or formed or made some steps to protect green IP? So, I've listed a few down. The most important ones. First is, of course, the IBC Green Inventory. There's the Green Tech Pilot Program from the USPTO. There's Clean Energy Research Center. There's Joint Clean Energy Research and Development Center, and of course, there's the Eco Patent Commons. Now, when it comes to impact of COVID on pharmaceutical countries and nations, India is world's third largest drug producing country. Along with drugs, India is, I think, 60% of the vaccines of the world are manufactured by India. Almost 40 to 70% for tetanus and DPT is provided by India to the WHO. Um, there is great this active pharmaceutical ingredient plays a great role in which India is doing really great things, is considered to be an important element by the pharmaceutical companies to deal with the ongoing pandemic. So most of the APIs are sourced from India, and 30% of which is supplied to the US by India. Even though India is well possessed globally for the manufacturing of API, the current disruption of supply chain that there is in the market is causes great cause of concern. Supply chains have been disrupted due to the lockdown, of course, all through the country, and which led to the stoppage of transportation services. Um, one of the greatest things that we have done due to the lockdown is that a task force has been set up, which includes prominent representatives from the pharmaceutical industry and Niti Aayog, which is a government think tank. It has been suggested that by providing subsidies, tax exemptions, fostering other pharmaceutical projects for development will encourage the industries. In this way, we will be self-reliant and the dependence of China will be reduced. Now, my favorite part of the presentation is new inventions in pharmaceutical companies, of course. Um, the pharma industry, according to me, is revolutionizing, but there are various um, pros and cons attached to it. So let's talk about the first point, which is artificial intelligence. AI is being used in the healthcare sector for various tasks such as data entry, data management, analysis of lab tests, etc. It is also being used in this industry to identify diseases, diagnose diseases, clinical trial research, identification of a rare disease, and invention of new drug, of course. A lot of AI programs are being patented these days. The source code of these artificial intelligence programs can be copyrighted. The patents for these can be filed by the company as per their utility. As much as AI has been successful in the pharma industry in discovering new drugs or testing new drugs, the main question that arises here is how will the content produced by AI itself be protected? Basically, under whose name will it be protected and who will get the ownership of it? Now, when with the innovation today, even 3D printing of medicine and organs has become possible. This process begins from a digital file. That file is then transferred to the 3D printer, and the digital file starts converting it into a physical object. It is done layer by layer until the final product is achieved by the printer. It could only be thought of as fantasies earlier, but it's actually become a reality with the first 3D printed. I think drug was made in 2015. Now that 3D printing tech has come into force, it is all the more easy to reproduce products. This is as convenient as downloading music over the internet. The digital file, that is the computer aided design file, can be shared over the internet and can have innumerable reproductions. As of now, this technology is only patented as it is as an invention. But what is needed next is to prepare a sturdy portfolio of copyrightable files. These files could be design files, idea maps, etc. That will help it be protected for a longer duration. So as of now, patents are protected for 20 years, whereas copyrights are protected for as long as 60 years, even after the death of author of the work. Other challenges that occur are that as the CAD file is actually easily transferable, there can be multiple infringers. So more times it's reproduced, the more times it can be infringed. CAD file can cross borders very easily, and the patentee will not even come to know where all the file and where it has reached. So deciding as to which IP right can be claimed to protect the printed drug is little difficult. The patent system is designed to protect the conventional patents, and there is a need to upgrade the law so as to include this or include all the inventive steps needed for this. Augmented reality and virtual reality. So when compared to AR, where it creates an overlay of fictional components. So AR is basically how different are the two of them. So AR is where we create scenarios that exist in the real environment through computer programs, and virtual reality transports the consumer to a new reality altogether. But together, AR and VR have significantly uh, been used to the pharmaceutical industries. For example, AR was actually used by a giant pharma organization to create an experience that will help the doctors to know as to what migraine patients go through. So the pain that they go through, that the doctors might be able to feel it. This was actually an amazing use of AR and will definitely help in improving the experience of a lot of patients. So AR and VR programs can actually be protected under copyright law as per the definition of computer programs, along with the literal elements, that is source code, object code, etc. The protection is also given to non-literal elements. Non-literal elements like, say, structure, user interface, organization of programs, etc. The protection of non-literal elements is a little difficult, but there was a test. Yeah, there was a test laid down by in this particular Computer Association Dell Limited versus Altai Inc., in which the abstract filtration test was first adopted to determine which of the non-literal elements can be protected. Now, when it comes to blockchain, the blockchain is any kind of information that needs to be stored privately, and blockchain is a new way of doing it. This can be used vastly in the pharma industry for better tracking of drugs, effects of drugs, amongst others. The prime objective of blockchain are security, trust, transparency, and accountability. Currently, the IP system is not very well versed to deal with such a technology. There are already instances of theft of copyrighted works, and this is quite a genuine concern. The concerns in case of IPR is not only restricted to implementation issues, but appropriate administration of IP resources likewise ended up in a similar testing work. In this manner, IPRs coupled with bigger authoritative commitments need a new look in the current advanced scheme. Now, when it comes to IoT or Internet of Things, it is a system of interrelated computer devices, mechanical and digital machines provided by UIDs, and the ability to transfer data over a network without requiring human to human or human to computer interaction. Now, system of connected devices with sensors can diminish the dangers of glitches, yes. But of course, there are other problems that arise when it comes to the protection of the same. Big companies such as Google or Dell spend actually a lot of money in IoT technology. This tells us about how this sector has potential for attaining revenues in the near future and relation of the IPR. But of course, the challenge that we spoke about, the challenge here is if the standardized technology is patented as a whole, no one will be able to use it without infringing the patent. This will eventually hamper the growth of IoT, and therefore these patents must be registered as standard essential patents in each country, and also licensing of these must be done for good use. Now, a few ways that the government worldwide have taken steps to build a greater IP scheme. So a few things like the extension of 2015 to 2020 foreign trade policy. There is a revision in Schedule 2 of the Indian Trade Classification of Export Items. Information Technology Act of the Indian Information Technology Act 2000 has also put in under its ambit governing cyber crimes, and of course there is the amendment of the patent rules. Now, coming to the end of the presentation, there is a I know I've put in a lot of information for you today, but I wanted to discuss a few meaningful inventions that are going around globally, and the problems that we're facing as IP specialists because of one, maybe the government or the legislature, and second, of course, because of the pandemic. So a few recommendations that I can list down is probably we need better laws to maintain a balance between excuse me, the protection of owners and the free flow of information, which will this will probably facilitate more inventions and innovations. The IPR policies have to focus more to promote healthcare, and of course, availability of various drugs. To probably get have availability of various drugs instead of focusing on generating revenue and granting patents. Now, what happens is that with the advent of science and technology, better laws governing each and every area relating to science and technology should be inculcated in the present regime. But there is only one way to go, and which is upwards. And given that the world is so tiny as it seems, we're all connected in some way or the other. I'm sure that we will find ways to overcome the general problems that are associated with our everyday life. And of course, patents, especially patents, I would say, we don't even realize what an important role that it plays in our everyday life, be it a lawyer or not. Um, and of course, I have great belief that we will be able to get not only through this pandemic, but get through the problems in the legislation as well. So, with that, thank you very much for listening in. Gisela, if you're there, the floor is yours.
Yeah. So thank you so much for that lovely presentation. That was very informative. Miss Leticia, are you online?
I'm here.
Yes. So with this, we will wind up with session 2. So before that, we have some questions that had come up. So our first question is for Ms. Leticia. Thanks for the presentation. You said try out some names ABCD for trademark. Can you elaborate? Test means to disclose or use in the market.
Yes, first of all, it's important to understand that many times you have to consider the phonetic names, the name, not only written name, but you have to understand the sound that the name does, because sometimes you put it in the market thinking about this will be a good name, but people do not spell it okay. So in my opinion, it's good to do a test before with your audience, with your public, to understand what does they understand, what does they think about when you say that name. And you have to do this with some kind of research, written research and spelling research, because then you can understand if your name, if what would you think about this name is okay, or if you are thinking about some kind of name that is not okay. Also, it's important to understand the social medias and the domain name, if it's also available. And you have to do this research in the PTO that you are going to register your trademark, because it's you have to think about it in each country you'd like to protect, and you have to think about this kind of protection in other countries if your business go abroad. So that's my strategy. And also, as I said, you can hire someone to do this work for you. It must be expensive, but I believe if you would like to know how to do, it's not difficult. You can do by yourself once you have in mind that you have to test it in the market before. I think it's okay. It's clear for.
Yeah, sure.
Okay.
Actually, I quite agree with Leticia, because when practically it comes to that prior art search is so important, because tomorrow if you start using your mark or your logo and realize that somebody is already been using that for some other purposes, you can't go back. So it's better to be prepared, right?
Yes.
Right.
Okay, thank you so much. And our next question, I think that's for Ms. Namrata. Can an IPR be transferred to a person who is legal hire of the rights owner after it's patented or a registered TM? In some situations, it seems to be required.
I think I
Hello?
missed a part of your.
Sorry. You didn't hear me? Are you online?
I know no, I'm there's some connection. Could you just repeat the question? I just
Yeah,
heard
I'll
a
just
part of it.
repeat the question.
Yeah.
I'll repeat the question. It's like, can an IPR be transferred to a person who is legal hire of the rights owner after it's patented or a registered TM? In some situations, it seems to be required.
Right. So I think the person answered the question themselves, that of course that if it is required, and even if it's not required in certain ways, that but there is a provision to transfer the IP, whether it's in trademark or patent or even in design, you can very well do it, either while it's in the process or even after registration.
Okay, thank you so much. And our next question is, in India, can we apply for, sorry? Yeah, can you hear me now?
No, my video is going on and off, yeah.
Okay. And Miss Leticia, are you there online?
Yes, I'm here.
Okay. I think both of your videos keep going and coming. Okay. I hope you can hear me, both of you. Okay. And our next question is, in India, can we apply for product patent after launching it in the market, or patent has to be applied for before the product launch? Does it differ from product categories?
As I studied, you can confirm, please. But as I studied, you can also put in the market. You have 1 year of grace period, like Brazil. Is it okay?
Okay.
I think.
Ms. Namrata, what is your opinion towards that?
Right. So in India, that we've seen practically that you should not, if you do want to protect your patent in any way, you should, before actually, if a client comes to me, I send them a piece of paper asking them to explain if at all they have done any prior displays of their IP or patent, which is not prohibited, but it is not suggested at all. So if you plan to protect IP or any of IP, and specifically patent in India, you should not be displaying it or even discussing it with any third person prior to filing an application.
Okay. Thank you, both of you. And our next question is, if the product is an outcome of an academic research, which should be done first to secure the patent? Should it be applied for patent first, or as a standard practice, it should be published in a journal first? Should I repeat the question? Hello? Can you hear me?
Yeah, I can hear you in parts, unfortunately. But I got the
Okay.
question that
Yeah.
if 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 through a research, if the product is that you've invented something in research, should you first protect it, or should you first apply it in a journal? So I would say it should be the first. You should protect it, and I think I would suggest doing it simultaneously, because probably publishing it in a journal, and through the time it takes for people to read it, tomorrow if somebody reads it and wants to infringe it or make their own version of it, by that time you should have an application in place so that you can stop the infringer.
Okay. I hope that's clear to the participant. And we'll move on to our next question. The next question is, drugs developed by computer-aided drug design will be patented in whose name?
That is where we, as when we spoke about, when I discussed the problem areas or the challenges when it comes to patent law, it's gray, but the obvious part is that if you're the innovator, if you're the inventor, then it's in your name. But if you are working for hire for somebody, for a company, then it's in their name. So that's the simpler version of an answer. But for getting a detailed version, we'll have to get into the different aspects and challenges.
Okay, okay. And we'll move on to our last question.
I unfortunately cannot hear you. I think I can hear Leticia. Anyway, yeah, go on.
Miss Leticia, are you online? Hello?
Hello?
Yeah. You're audible now. You were saying something. Can you repeat it? I think her audio is off again.
Right.
Okay, we have another question. And it goes like this. When a new device is tried, if a part of the new design is already used for a different purpose, could patent be still expected? Miss Leticia, are you online?
Sorry, I can't hear you. Can you hear me?
Okay, yeah, we can hear you. Shall I repeat the question? It says in the chat box, we have got a participant asking the question. When a new device is tried, if a part of the new design is already used for a different purpose, could patent be still expected?
If it's already used, no. If you had already published it, no, you cannot file a patent. That's my opinion. Can you complement, please? I'm afraid to say something that is not okay for India, because
No, I actually agree that that's how it goes in India as well, that you cannot do it.
Okay, and with this, we come to an end of our question and answers. I hope we don't have any further questions. Dear participants, if you have any more questions related to the session 2, you may ask to our speakers who are available right now, and also to the attendees who are watching us live on YouTube. This is a golden opportunity to get your questions cleared face-to-face live on this. And with this, we'll move on to the end of the session 2. Thank you, both of you, Ms. Namrata Pahwa and Ms. Leticia, who had joined us today evening. Thank you for your presentations. I hope it was very informative, and what I felt the same for the participants as well. And we have been receiving lovely comments in the comment section. And thank you, both of you. And Dear participants, tomorrow we'll be moving on to session 3, and we have an amazing 2 speakers coming up tomorrow with another part of intellectual property. And if you are a person who's watching us live on YouTube and haven't registered, yes, do register and do not miss any of our upcoming sessions. And we do have our upcoming webinar starting from August 14th, which is on PhD end-to-end assistance and guidance. So if you're interested, do subscribe to our YouTube channel and register for the live webinars. Similar way, we'll be moving on tomorrow with another episode. Thank you, both of you. Good evening.
Thank you.
And good day to all.
Thank you very much.
And dear participants, the presentations are uploaded in the file section. You can download by yourself. The PDF materials are provided for you related to the sessions. Do download them. And if you have more questions, you can write back to us on webinar@iferp.in. We'll make sure that we answer all your questions at the earliest. Thank you so much. And good evening to all.
Thank you. Bye.
Bye-bye.